Well, thank you, John, and good morning. It is great to be with you. It is great to be back with so many friends at Heritage. For all of you here, I would encourage you to settle down, get comfortable, and I will do my very, very best to keep my remarks to under 21 hours. Let me say at the outset also, it is a particular privilege being here at Heritage. Heritage plays such an important role in helping articulate and defend conservative principles across this country. And in no fight has that been more apparent than in the fight over Obamacare, over stopping the enormous harms that are coming from Obamacare. Heritage has played an absolutely leading role in helping lead that fight, and I certainly am grateful to be fighting alongside Heritage. Now, the topic this morning is not Obamacare, but is instead two of my favorite topics in the world, one of which is U.S. national sovereignty, and the other of which is the structural constraints that are present in the Constitution that protect our liberty. And both of these are implicated by the Supreme Court's case, Bond versus United States. So what I'd like to do is I'd like to talk to you for a few minutes about Medellin versus Texas, which John mentioned, and tell you a little bit of the background of Medellin because that's a case with which I was intimately involved. And then transition over to talking about Bond and how many of the issues in Medellin are implicated in Bond, and go to core issues of sovereignty and the structural protections of our liberty. Medellin is a case that began with a horrific crime that occurred in Texas in the early 1990s, where two teenage girls were tragically attacked and murdered by a gang. And it was as ugly a criminal case in terms of what happened to those little girls as you would ever see. And the case took a very, very strange turn, because what happened in Medellin is one of the gang members, a fellow named Jose Ernesto Medellin, he was apprehended, he confessed in writing, and he was convicted. But it so happens that Medellin was a Mexican national. He had been born in the nation of Mexico. And although he had lived almost his entire life in the U.S., he had come to the U.S. as a very small child, he was technically speaking still a Mexican national. And there are a series of international treaties, most notably the Vienna Convention on Consular Affairs, that provide that when an individual in a signatory nation is arrested in a foreign nation, that you have a right to contact your consulate. The consulate has a right to provide you assistance. And it's been interpreted as putting an affirmative duty on the arresting officials to inform you of that right. There's no dispute, nobody informed Medellin of his right to contact the Mexican consulate. So he was convicted, he was sentenced to death, and some 4 years later, on federal habeas review, on a collateral review of his convictions, his lawyers raised for the first time the Vienna Convention issue. And roughly concurrently, the nation of Mexico sued the United States in the International Court of Justice, which is the World Court, based on the Vienna Convention. And the World Court issued a decision in a case called Avena that was a remarkable decision. It was a decision that purported to order the United States to reopen the convictions of 51 murderers across this country, all of whom were Mexican nationals, all of whom had been convicted of murder, all of whom, for one reason or another, local law enforcement had not informed them of their right to contact the Mexican consulate. That was the first instance of a foreign court trying to bind the United States and bind our criminal justice system. It was an extraordinary assertion of power by the World Court. Well, unsurprisingly, Medellin's lawyers immediately began seizing upon this decision from the World Court and saying under the World Court, he was entitled to have his conviction reopened. And the case went to the U.S. Supreme Court twice. I argued it twice in front of the U.S. Supreme Court. I guess the first time we didn't do a good enough job because we had to have a do-over the second time. The case took an even stranger wrinkle, though. because while the case was pending, the President of the United States, whom I would note was a Republican, George W. Bush, signed a 2-paragraph order that purported to order the state courts to obey the World Court. It was an extraordinary order. And so the second time we argued Medellin, when it was Medellin versus Texas, there were 2 issues before the Supreme Court. Number one, does the World Court have the authority to bind the U.S. justice system, to reopen final criminal convictions? And number two, does the President of the United States have the authority to order the state courts to submit to the authority of the World Court? Now, those were, for anyone who is a student or fan of constitutional law and the constraints upon the exercise of federal powers, these were issues that really go to the heart of federalism, go to the heart of separations of powers. And Texas argued in Medellin that the answer to both of those questions was resoundingly no, that the World Court had no authority to bind the U.S. justice system, both because the treaties at issue were not what is called self-executing. And in treaty speak, and for those of y'all who don't carry the burden in life of being lawyers, there is a distinction of 2 different types of treaties, those that are self-executing and those that are non-self-executing. A self-executing treaty has binding domestic legal force by virtue of its ratification. It doesn't need anything additional to have binding domestic legal force. A non-self-executing treaty is essentially a contract between nations, but it doesn't have binding domestic legal force unless and until Congress, in conjunction with the President, passes legislation giving it binding legal force. So those are the 2 types. In Medellin, the Vienna Convention on Consular Affairs was non-self-executing, which means everyone agreed it didn't have binding legal force. One of the things the President was effectively trying to do with his memo was unilaterally transform a non-self-executing treaty into a self-executing treaty that is binding. And the Supreme Court in Medellin, it was interesting, just about every pundit, just about every academic, just about every media outlet covering Medellin thought that we didn't have a prayer. That was the conventional wisdom. I remember actually Heritage organized a moot for me to get ready for the argument that was incredibly helpful. And at the end of the day, the Supreme Court ended up agreeing with Texas across the board. We won 6-3, with a victory where the court concluded, number one, the World Court has no authority whatsoever to bind the U.S. justice system. And number two, the President of the United States has no authority to order the state courts to obey the World Court. Those were both incredibly significant decisions going to U.S. sovereignty and also going to the structural constraints on government. All right, so let's fast forward to Bond versus United States, case that the Supreme Court is getting ready to consider. Now, Bond, a Pennsylvania woman named Carol Ann Bond, committed a local crime, an unfortunate crime. She discovered that her husband had been with another woman and had impregnated another woman. And she was pretty unhappy about that. I have to admit as an aside, you know, one of my favorite characters in Washington was Dick Armey. And one of my favorite things Dick Armey ever said is during the height of the Monica Lewinsky scandal, someone asked Dick Armey, Leader Armey, what would you say if you had been President Bill Clinton? And Armey's response, he said, well, I wouldn't say much of anything, because I'd have been lying in a pool of my own blood, and Mrs. Armey'd be saying, how do I reload this darn thing? So, Mrs. Bond was not quite as drastic as Mrs. Army might have been, but she nonetheless got a chemical and put it on the mailbox and doorknob of this woman, and this other woman suffered burns from this chemical. Now, look, it's an unfortunate act of assault. It's something state law, state criminal law, for hundreds of years has been able to handle. If you use chemicals to burn someone, you'll be prosecuted. That's assault, and that's, our criminal justice system works pretty well on that. Except she wasn't prosecuted locally. She was prosecuted instead for violating the Chemical Weapons Convention Implementation Act, which is a treaty. It's an act that was implementing a treaty prohibiting chemical weapons. Now, in this case, it wasn't sarin gas that was used. It wasn't something typically understood as chemical weapons in the sense of weapons of mass destruction that are typically the subject of these treaties. It was chemicals that were harmful and burned this one. And the central question in Bond is whether a treaty can expand the authority of the federal government beyond the constitutional limits that would otherwise apply. That is a tremendously important question, and I would note that at the heart of what's at issue in Bond is a famous sentence from Justice Oliver Wendell Holmes in 1920 in a case called Missouri versus Holland, where in that case the court wrote, quote, "If a treaty is valid, there can be no dispute about the validity of the statute implementing it under Article 1, Section 8, as a necessary and proper means to execute the powers of the government." Now that snippet, that sentence has been relied upon over and over again for the proposition that the treaty clause can be used to circumvent the structural limits on the power of the federal government. Now, I have to tell you, in my view, that proposition is an absurd proposition, that the treaty clause can subsume, can trump every other structural protection of the federal government. But that phrase has been cited for that proposition over and over again. Indeed, in Medellin, the federal government relied on Missouri versus Holland and said, well, yes, it is unusual. In fact, the Department of Justice was quite candid. They said unprecedented for the president to attempt to order the state courts to obey the world court. But under Missouri versus Holland, the treaty clause enables all sorts of things that wouldn't be able to happen otherwise. I will note, by the way, as an aside, I want to go back to Medellin for a second. We had an interesting array of amici in Medellin who supported the state of Texas, who came in supporting the state of Texas, because in my view, Medellin was a separation of powers case. It was about protecting the authority of Congress, protecting the authority of the Supreme Court, and protecting against executive overreach. And in particular, we had one brief that was signed by a number of law professors, including John Yoo, whom many of you will know, who is an academic, who is a friend, who is known as one of the most conservative law professors in the country and one of the most vigorous advocates of robust executive authority. That same brief was also signed by Professor Erwin Chemerinsky, who's the dean of the University of California at Irvine, who is very well known as one of the most liberal law professors in the country. I am not aware of any other issue in which John Yoo and Erwin Chemerinsky have joined forces. They both joined a brief supporting Texas and Medellin, and why did they do so? Because the potential, if in the context of a treaty, the president had the authority to pick and choose which laws to follow, that had enormous potential for damage to our structural constitutional system going forward. Indeed, I'm reminded of when I found out about the president's order in Medellin. The then U.S. Solicitor General, Paul Clement, called me on the phone. Paul is an old friend, and Paul said, This was February of 2005. And Paul said, "Ted, are you sitting down?" Now that's a bad sign. When the conversation begins with, "Are you sitting down?" you're pretty sure the rest of it is not going to end up the way you want. And Paul explained to me that the president had decided to sign this order, ordering the state courts to obey the world court. And then Paul, being a good soldier, made the argument, but look, you should be very, very comforted, because the president keeps his finger on the trigger. The president gets to decide when to implement this new power. And my response on the phone, I said, number one, Paul, given how it's being implemented right now to undermine the convictions of 51 murderers across this country, that does not give me much comfort. But number two, Paul, there came a Pharaoh who knew not Joseph and his children. Even if you're arguing George W. Bush will constrain this power, he's not going to be the last president to serve in office. And a president that has the authority to set aside U.S. law is a president that has far more authority than the Constitution gives any president. And so how did John Yoo and Erwin Chemerinsky come together? Because on each of them, I called each of them and made the case. And I said, imagine, when you were talking to a conservative, we had a number of conservatives, imagine, tried to pick a specter that in 2005 would deeply concern conservatives. Imagine a President Hillary Clinton who decided to use this new power to set aside state laws with which she disagreed in the name of international comity, in the name of not even enforcing mandatory treaty obligations, but simply comity between the nations, which was the predicate for the Medellin Order. Imagine, for example, a President Hillary Clinton signing a 2-paragraph order setting aside the marriage laws in all 50 states and saying every state shall now allow gay marriage because I have determined this would further international comity. Or another example, imagine a President Hillary Clinton saying, our allies really don't like that a number of states have capital punishment laws. So I'm writing a 2-paragraph order setting aside the state capital punishment laws in every state because this would further international comity. And I argued, listen, no matter what you think of the president doesn't have the authority to flick state laws off of the books on whim and judgment. Now with Professor Chemerinsky, I tried to pick the most terrifying thing a liberal law professor could ever imagine. I said, imagine President Dick Cheney. Erwin began breathing heavily at that point. And I said, it is not at all difficult to imagine, for example, a President Dick Cheney saying, California environmental laws limit productivity. Our allies, they have global multinational corporations. They're unhappy. I therefore set aside all California environmental laws. Or for that matter, tort reform. Those pesky trial lawyers keep suing people. I therefore decree there shall be no punitive damages in the United States of America. Now look, some people in this room might like that as a policy outcome. Whether you like it or not, it is unequivocal the President of the United States doesn't have the authority under our constitutional system to simply decree it by whim. That unified the left and the right in Medellin saying, regardless of who the president is, we don't want that much power arrogated to the president. Well, let's go to Bond. There are two types of restrictions you can think of that ostensibly the treaty power could get around. One are explicit prohibitions. The Bill of Rights. I'll read you again the sentence from Missouri versus Holland. If a treaty is valid, there can be no dispute about the validity of the statute implementing it under Article 1, Section 8 as a necessary and proper means to execute the powers of government. Now, surely, it cannot be the case that the president could sign a treaty, say, giving away our First Amendment rights. By the way, if you go to Europe, the First Amendment is an alien concept in Europe. The notion of hate speech is something that is prosecuted. But surely it cannot be the case that the President of the United States could circumvent the First Amendment, could restrict the freedom of the press, could restrict our freedom of speech, could restrict our freedom of free exercise of religion through simply signing a treaty, finding some nation somewhere signing a treaty and somehow getting the Senate to ratify it. Surely it could not be the case, as this president is trying to do with the UN Small Arms Treaty, that a treaty could be used as a backdoor way to undermine the individual protections of the Second Amendment right to keep and bear arms. The Bill of Rights would be a hollow document indeed if all of those protections, if every one of the Bill of Rights was read as having an asterisk at the end, unless a treaty is passed that takes away this right. And I would note in Medellin, the second time, Chief Justice Roberts asked a question that went right to this. Chief Justice Roberts asked the opposing counsel, Medellin's lawyer, he said, well, what about if the World Court had simply said the arresting officers that failed to notify Medellin of his consular right, lock them up and throw them in jail for 5 years? Suppose the World Court had ordered that. Go and arrest that man and put him in jail for 5 years. Now that contravenes a number of provisions of our Bill of Rights, including the right to trial by jury. And the Chief Justice's question is, you can't possibly be arguing that simply because of the President's order, the United States would be obliged to go arrest the arresting officer and throw him in jail 5 years, because it would further comedy. That question, if you put it in the bond context, is exactly, can a treaty circumvent the express prohibitions, the rights in the Bill of Rights? But there's a second question, a related question, and one that really is the heart of bond, which is, okay, if it can't, and I think most people would agree that you can't use a treaty to undermine the Bill of Rights and the explicitly prohibited actions and powers of government. Well, then the second question is, well, are the structural limits on the power of the federal government different? Now, some would say yes. There are some, particularly in the legal academy, that view the structural limits as really all but non-existent. Kind of details. And, well, if it's a treaty, yeah, you can get around those. I have to say, in my view, I think the structural limits were fundamentally about protecting individual liberty, about restraining governmental power to protect the liberty of the citizens. And I would note, also at Medellin, the issue of structural limits on government was raised a couple of times. One, with regard to the President's order in Medellin, the Department of Justice argued that the President had authoritatively interpreted the treaty, and that was binding. And I got to tell you, there are very rare times in the life of a lawyer where you get to go into a court, particularly the Supreme Court of the United States, and argue relying as a principal authority on Marbury versus Madison. To stand before the Supreme Court and say, Mr. Chief Justice, it is emphatically the province and duty of this court to say what the law is. And yet that was very much our argument there, that in attempting to impose a binding interpretation of the treaty that was contrary to what the Supreme Court had said, that the President was usurping the Article III authority of the Supreme Court of the United States. And we argued no treaty could give away the Article III decision-making power of our courts to another body. That exceeded the treaty writing authority to hand over the core constitutional responsibility of our federal courts. Now, I'll note the first time Medellin was argued, Justice Scalia asked a question quite similar to this. But he asked Mr. Medellin's lawyer, he said, tell me, do you think that the President could sign a treaty making Kofi Annan the Commander-in-Chief of our U.S. Armed Forces? Could the President of the United States, by treaty, give away his core Article II authority? Now, Medellin's lawyer didn't really have an answer to that question. because the answer is self-evidently no. Of course not. Of course the president could not make anybody else commander-in-chief except for the president of the United States, who is the only individual given the authority to be commander-in-chief under Article 2 of the Constitution. But the problem is, if he said that, that immediately said, well, then what? It led to the follow-up question, which is, if he can't give away his Article 2 power, why could the president give away our Article 3 power? But what it would also open the door to, if a treaty is not bound by the structural limitations, either of separation of powers between Article 1, Article 2, Article 3, the different branches of government, or federalism and the 10th Amendment, the limits between the federal government and the states. What that would do is essentially say that the principles of federalism, the structural limitations on the federal government, they're second-class constitutional provisions. Unlike the Bill of Rights, these other ones don't really matter a whole lot. So, for example, the Lopez decision, landmark decision of the Rehnquist Court that struck down the Federal Gun-Free School Zones Act as being beyond the authority of Congress to legislate something that was purely intrastate. Gun-Free School Zones Act was justified as a matter of regulating interstate commerce, and the Supreme Court, in a decision my former boss, Chief Justice Rehnquist, wrote, said, look, we start with first principles, and it is beyond the authority of Congress to regulate what should be a local state criminal matter. Now, it doesn't mean it shouldn't be illegal. It's just not everything that is illegal has to be illegal as a federal matter. There's a reason we have 50 states and local governments. If the meaning of the Missouri versus Holland snippet is that a treaty can circumvent the enumerated powers in Article 1, Section 8, that you don't need to ask, does Congress have the authority to legislate here to begin with, then it means there's an easy way around the Lopez decision. You simply sign a treaty with anybody that says we're going to agree to ban guns in all of our schools. You get it ratified, and if it's no longer relevant, does the federal government have the authority to regulate purely local matters? You suddenly have a backdoor giving the federal government the authority to do it anyway. Another issue similar to that is the Morrison case, where the court struck down a portion of the Violence Against Women Act. Now listen, everyone agrees violence against women and against anybody is a terrible thing and should be punished, and should be punished vigorously. Indeed, in this case, Ms. Bond used chemicals to burn someone else. There's no doubt that, assuming those are the facts, that she should face criminal prosecution for that conduct. The question is, who should prosecute her? Under which law? And what the court concluded in Morrison is, listen, the states have, for centuries, had robust laws protecting against violence on a purely local matter. There's no need for a federal law governing violence between two individuals on a purely local level that doesn't cross state lines, that doesn't implicate interstate commerce. That is a matter our Constitution has left to the states. If the broad interpretation of the Missouri versus Holland snippet is accurate, Morrison can go away very easily. You now have a roadmap. If you find the limitations on the federal government's authority irksome, any president has a simple path to get around it. Find any nation, doesn't matter which nation, any nation anywhere in the world, negotiate a treaty agreeing to do what you couldn't do otherwise. And if the Senate ratifies it, and by the way, that means you can cut the House of Representatives out of everything, then suddenly the federal government has authority it didn't have before. I would suggest to you that is a radical interpretation of the treaty power. And that is what is at issue in Bond. Does the treaty power enable the federal government to circumvent the structural limitations on the authority of the federal government? Now, Missouri versus Holland, it may be possible for the court to distinguish that case. There are grounds on which you can distinguish it, but if you can't distinguish it, then Missouri versus Holland should be overruled. Because the proposition that the treaty clause is a trump card that defeats all of the remaining structural limitations on the federal government is not a proposition that is logically defensible. So that's what the court's going to be wrestling with. In Medellin versus Texas, they did the right thing. They defended U.S. sovereignty. They upheld the structural limitations on government power, which serves to protect individual liberty. And it is my hope that in Bond versus the United States, the Supreme Court does the same thing, that it interprets the treaty power with an eye towards the 10th Amendment, with an eye towards our federalist system and the structural limitations on the federal government, and with an eye towards protecting United States sovereignty. Thank you.
The senator has graciously noted that he will take some questions now. We have time for a few, so if you please wait for the mic and ask a question rather than make a, treatise speech, that would be great. So right there.
Yes, sir.
So I'm pleased to be among all these literary legal scholars, so I hope you can clarify something for me. In the Medellin case, the president was effectively precluded from picking and choosing the laws he chose to enforce. Yet we've noticed in the last 5 years or so, the president has picked and choose lots of laws to enforce. Employer mandate, border enforcement. How is it that that happens now so routinely?
The question you ask is a terrific question, and it is one of the most disturbing aspects of President Obama's administration. This administration has not respected rule of law and has consistently flouted the constitutional limits on the authority of the president. As you note, the president has picked and chosen which laws to enforce and which laws not to enforce. In the immigration context, the president simply announced he wasn't going to enforce certain aspects of our immigration law. In the drug context, the Attorney General announced they weren't going to enforce aspects of our drug law. Now, as a policy matter, it may be that some people in this room agree with those policy decisions. Maybe those are particularly on the drug side. I think you would find people both on the right and left that think there may be some reasonable modifications of drug laws. But prior to this presidency, the way you had reasonable modifications of federal law is you went to Congress, you introduced legislation, you worked with elected representatives of both parties, you passed a change in the law, and you signed it into law. That's the way the constitutional system worked. What this president has begun doing, and it's a very disturbing pattern, is simply saying we're not going to work with Congress to get it changed. As the president said in 2 State of the Union addresses, if Congress doesn't act, I will. That is a dangerous assertion of power. The president under Article 2 has a constitutional obligation to take care that the laws be faithfully executed. If you look at Obamacare, the pattern on Obamacare has been really stunning. We all know big business has gotten a 1-year delay in Obamacare. Why? Because the president decreed it to be so. The statute applies on January 1. Now, for a couple of 100 years, when a statute says there is a legal obligation that applies on January 1, it meant on January 1 that legal obligation kicked in. This administration simply said, no, we're not enforcing that law. And in fact, they did so through a blog post from a mid-level Treasury staffer that was posted on a Friday afternoon. That pattern, I think, is very dangerous. And I'll note 2 things on it. Number one, in the Senate, I'm the ranking member on the Constitution Subcommittee. And in that capacity, we have put out a report detailing assertions of federal power by this administration. Bold, broad, aggressive assertions of federal power that this administration has made before the United States Supreme Court that have been rejected 9-0. And this report I would commend to all of you to go through. They argue that the federal government has the authority to put a GPS on your cars with no probable cause, no reasonable suspicion, just to know where you are. Now, as I read it, I thought the Fourth Amendment had something to say about that. And fortunately, the Supreme Court agreed, and 9-0 said, no, the Obama administration doesn't have that authority. There was another case, Hosanna Tabor, where there's an exchange that we quote in this report between the Obama Justice Department lawyer and Justice Elena Kagan. Now, you will recall Justice Kagan was the Solicitor General under President Obama, and I think it's fair I think all would agree that Justice Kagan is not a right-wing kook. This exchange with Justice Kagan, she asks the Obama Justice Department lawyer, is it your position that the First Amendment says nothing about whether and how a church may hire its ministers and the employees who work for the church? And the answer from the Justice Department lawyer was, we see nothing in the First Amendment that addresses the ability of a church to decide who its pastors are going to be and who work for the church. And Justice Kagan, from the bench, said, I find that position remarkable. That is, from the bench, President Obama's own Solicitor General saying, the idea that the First Amendment is irrelevant to the question of how churches select their ministers? And 9-0, the Supreme Court rejected it. So I would commend that report to everyone to see a catalog of egregious assertions of federal power. And the second final point I'd make on this, Medellin versus Texas. Unfortunately, there the president who made an assertion of overbroad federal power was George W. Bush. He's a Republican, the former governor of the state of Texas. And yet I'm very proud that the state of Texas went before the U.S. Supreme Court and said, no president, even if he is the former governor of Texas and a Republican, no president has the authority to give away U.S. sovereignty. And I would note one of the things that is disturbing is the almost total absence of Democrats speaking out at the abuse of executive power by the Obama administration. I spoke out very loudly when it was a Republican administration abusing its power. I thought it was striking when Rand Paul did his filibuster on drone policy that only one Democrat showed up on the floor to support us. That was Ron Wyden. The other 53 Democrats apparently had no concerns if the administration used drones to target U.S. citizens. And I hope in time, there have been historically Democrats who have been genuine civil libertarians, who have been concerned about overbroad power in the federal executive. And I hope in time you will see some Democrats with the courage to speak out and say, even if I might agree with this policy, the president doesn't have the authority to decree it unilaterally, and any time you see too much power arrogated in the president, it undermines the liberty of everyone.
Question?
Thanks. Senator, thanks for spending the time to talk about the treaties and some of the background. And I wanted to ask about a specific treaty. I think it's likely going to be a subject of a Senate Foreign Relations Committee hearing coming up. I'm sure you're very familiar with it, Convention on the Rights of Persons with Disability. And so today you've brought up how important it is. These are important things, and there's other implications. And so just briefly, my name's Chris Nowim. I'm a Iraq veteran. I work at Vets First Veteran Service Organization. I'm sitting here with Jeff Steele from the American Legion. And most of our work usually focuses on bills, legislation, House Veteran Affairs Committee, Senate Veteran Affairs Committee, rarely treaties. this is a treaty that veteran service organizations are supporting because of the relationship with disabled veterans, and I know you're probably familiar with it, and why we're supporting it is kind of the overseas travel, retired military disabled veterans living overseas, and so I'm pretty sure you're probably opposed to it, but I guess the question is, through the RUDS process, or reservations, understandings, and declarations, could you speak a little bit to how important those are to make a treaty better, or to make them amenable to a conservative senator like yourself? How important is that? And our veteran community is supporting it. So, is there a way where we can be a resource, or help it be better in that respect? If you could speak to that, and thanks in advance.
Well, thank you for that question. Let me say thank you to your work with our veterans, which is incredibly important. The treaty with disability, when it's come up before the Senate, it has not been ratified. And the reason it hasn't been ratified was, and I was not serving in the Senate the last time it was voted, so I have not had the opportunity to vote on it yet, but the reason it wasn't ratified was because of concerns of U.S. sovereignty. In the United States, we have vigorous laws, indeed laws that lead the world in terms of protecting the rights of those with disabilities. The Americans with Disability Act expands the access for people with disabilities, and made major inroads in terms of allowing people who previously had not been able to access public facilities to be able to access public facilities. That's existing law now. The concern over the disability treaty is that it would undermine sovereignty by creating the ability to use international bodies to enforce extant legal obligations on the United States without going through the legislative process, without going through Congress. That's the concern. It is a real concern. I would note, in terms of access elsewhere, other countries who have signed on, to the extent they wish to comply with the treaty, will do so regardless of whether the U.S. ratifies that treaty. If other nations that have signed on decide to expand their access, which is the issue you're focused on, they're going to do it or not, regardless of whether the United States is a signatory, because there are other nations that are signatories. And I would note what happens sometimes in these treaty issues. You saw this in Medellin. The nation of Mexico argued in front of the World Court and argued in front of the Supreme Court that the U.S. should be bound by the judgment of the World Court. And in fact, we had 90 foreign nations come in against the state of Texas in front of the U.S. Supreme Court, arguing that the U.S. justice system should be bound by the judgment of the foreign court. Do you know how many of those 90 nations enforced judgments of the World Court in their courts? 0. It literally was 90 nations saying the United States alone should give up its sovereignty. We have never done this, and we don't intend to. But the United States should do so. That's part of the concern with the disability treaty, is that ratification is not going to materially change the degree of compliance by foreign nations, but it is going to open avenues to undermine sovereignty and challenge U.S. law. And I think if those issues are not adequately dealt with, I think the treaty is unlikely to be ratified. With that, I just want to thank you all for being here, and God bless you all.